Okay, welcome everyone to the October 2023 meeting of the Humanist Society of Santa Barbara. My name is Judy Flattery. I'm the president of the society. We welcome new members, anybody interested in humanism, and anyone interested in contributing their talents to our organization. I always like to take a look at why are we having this talk? How does this talk today relate to humanism? And in this case, it's a mic drop moment because we are committed to the principle of the separation of church and state. And we're so glad to have Kalli Joslin here today. Kalli Joslin is the Stephen Gay Constitutional Litigation Fellow at Americans United for Separation of Church and State. She received her JD cum laude from Georgetown University Law Center, where she served as the editor-in-chief of the Georgetown Journal of Gender and the Law, and as a student attorney in the Civil Rights Clinic. She also interned for Lambda Legal and the ACLU program on freedom of religion and belief. At Americans United, she is counsel on Blackmon v. Missouri, the abortion case in Missouri. So with that, I'll turn it over to you, Kalli, and thank you so much for being here with us today.
All right, thank you so much. And hello again. As Judy said, I'm Kalli Joslin. Americans United for Separation of Church and State is a national nonprofit leading the fight to protect religious freedom for all and prevent the misuse of that freedom to harm others. Thank you to the Humanist Society of Santa Barbara for having me. It's an honor to be able to speak to you all this afternoon, or for those of us on the East Coast, this evening. This presentation will be in 3 parts. First, I'll lay some groundwork on what the U.S. Constitution says about the separation of church and state and how the Supreme Court has interpreted that language, especially in recent years. Then I'll talk a bit about some of the work Americans United is currently doing in federal and state courts to protect public education, non-discrimination laws, and reproductive rights. And I'll wrap up by expanding on our Reverend Blackmon v. Missouri case, challenging abortion bans in Missouri State Court as an unconstitutional establishment of religion. And there's a Q&A portion at the end where I'm happy to answer your questions. So let's jump in. The First Amendment begins with the 2 religion clauses, which are here on your screen. You might note, if you haven't looked at this closely before, that it begins with Congress shall make no law. But the First Amendment doesn't just restrict Congress. The president can't violate these protections any more than Congress can, nor can any other government actor. If you work for the government and are performing government duties, the First Amendment restricts what you are able to do when it comes to infringing on people's religious exercise, free speech, etc., all of the First Amendment freedoms. And these restrictions also apply to state and local governments. So the takeaway is that these clauses apply just as much to a public school teacher running her classroom as they do to Congress passing laws. As you can see, there are 2 different religion clauses. The Establishment Clause prevents the government from establishing an official religion, taking sides in religious disputes, or favoring one religion over any other religion or non-religion. The Free Exercise Clause protects an individual's right to believe and practice their faith. Since the founding, these clauses have been understood as working together to demand government neutrality toward religion, thereby protecting religious freedom for everyone. This used to be widely understood and uncontroversial. But in recent decades, conservative judges have increasingly viewed the clauses as being, at the very least, in tension, if not at outright war with each other. At least 5, possibly 6 justices on the current Supreme Court believe this. The conservative view is that long-settled anti-establishment interests, like prohibiting government funding of religion, infringe on free exercise rights. To give a common example of how this plays out, if a law provides a benefit, like government funding, it may specifically carve out religious groups from receiving that benefit. This is the government's effort to remain neutral toward religion because providing support to one religion necessarily comes at the cost of other religions and non-believers. This is the Establishment Clause at work. But some conservatives have increasingly insisted that the failure to give government support to religion is religious discrimination that violates the Free Exercise Clause, hence the purported tension. And the Supreme Court, buying into these conservative arguments, has been chipping away at the Establishment Clause for years. To make this all a little more concrete, we can look at the evolution of the Supreme Court's views on the constitutionality of giving publicly funded school vouchers to private religious schools just over the last 20 years. Americans United opposes school voucher programs because they divert public funds away from our public schools toward religious schools that often turn away or expel children with disabilities, LGBTQ plus students, or students and families who don't adhere to the school's religious code of conduct. Vouchers are not the only issue we work on or the only religion issue on which the Supreme Court has shifted in recent years, but if I tried to cover everything in this presentation, we'd be here until next year. So, starting in 2002, the Supreme Court held in Zellman v. Simmons-Harris that Ohio's private school voucher program could give government money to religious schools without violating the Establishment Clause if that government money goes to religious institutions only through the deliberate choices of individual recipients. Basically, a state may, not must, may fund religious education, but can only do so indirectly. In the case of vouchers, it's parents who choose whether to spend those vouchers at religious private schools or non-religious private schools. So the government isn't choosing to fund religion directly. That individual choice is crucial. Zellman was a 5-4 decision. The 4 liberal justices dissented, warning specifically about the harm to the Establishment Clause and the separation of church and state. Justice Stevens, in his dissent, said, "Whenever we remove a brick from the wall that was designed to separate religion and government, we increase the risk of religious strife and weaken the foundation of our democracy." Fast forward 15 years. With some new justices on the court, the Supreme Court held in Trinity Lutheran Church of Columbia v. Cummer that Missouri's refusal to consider churches for a competitive playground resurfacing grant violated the Free Exercise Clause. Missouri excluded churches specifically because it was worried about violating the Establishment Clause by giving them government funds. Now, Trinity Lutheran is not a voucher case, but it affects how the Supreme Court understands vouchers in later cases. What's important from Trinity is that the court distinguished between the religious status of the recipient and religious uses of the money, and it found that this was unconstitutional status-based discrimination because Missouri had said no churches can get this money, rather than no government money can go towards funding religious education, which would be a religious use. So government money going directly to a religious use would still violate the Establishment Clause. Justices Sotomayor and Ginsburg dissented from Trinity Lutheran. In her dissent, Justice Sotomayor said, "The court today blinds itself to the outcome this history requires and leads us instead to a place where separation of church and state is a constitutional slogan, not a constitutional commitment." And in 2020, in a strange ruling, the court held in Espinoza v. Montana that the Montana Supreme Court's ruling striking down the state's voucher program also violated the Free Exercise Clause. It's a little confusing, but I'll explain in a second. The majority applied the same status use distinction from Trinity, and it claimed this case was just like Trinity. Religious schools had been discriminated against based on their religious status. But the court shouldn't have decided Espinoza at all. The Montana Supreme Court's ruling, which the U.S. Supreme Court overturned, struck down the entire voucher program as violating the state constitution's no-aid clause. So this isn't a normal free exercise case where a religious entity is treated differently from similar secular entities or coerced into giving up its religious convictions to get a government benefit. Under the Montana Supreme Court's decision, no private schools could receive vouchers because the whole program was gone. Again, the 4 liberal justices dissented in Espinoza. Justice Breyer's dissent noted that the majority had really narrowed the status use distinction from earlier cases. And Justice Sotomayor said this court has never before held unconstitutional government action that merely failed to benefit religious exercise. And that gets us to Carson v. Macon. In June of last year, the Supreme Court held that a requirement in Maine's voucher program that funds be used for non-religious purposes to provide the rough equivalent of public school education violated the free exercise clause. In Carson, they abandoned the status use distinction altogether, which went one step further than Espinoza. Espinoza said excluding schools from vouchers based on religious status violated free exercise, but it didn't say the same thing about religious use. By the time Carson was decided, there were only 3 liberal justices on the Supreme Court. And Justice Sotomayor said in her dissent, "What a difference 5 years makes. Today, the court leads us to a place where separation of church and state becomes a constitutional violation." So from Zellman v. Simmons Harris in 2002 to today, the court went from saying states may give government funds to religious schools, which was itself an unprecedented decision, to saying that states must give funding to religious education if they're also funding private non-religious education. That shift has completely upended the court's earlier understanding of what the Establishment Clause prohibits. But that's not all. In another recent case, the Supreme Court even abandoned one of the primary tests the court applies to decide whether something even violates the Establishment Clause. How many of you have heard of the Lemon test? So last year, Americans United argued a case before the Supreme Court called Kennedy v. Bremerton School District. For some background, Joe Kennedy was a public high school football coach who was leading students in prayer at the 50-yard line at football games. You can see him there in the picture on the right, holding up a football helmet. The school district told him he had to stop doing that because it violated the Establishment Clause. Kennedy sued, and we represented the school district. The Supreme Court sided with Kennedy, and in its decision, it abandoned the Lemon test. But what is the Lemon test? It was named after Lemon v. Kurtzman, the case where the Supreme Court first articulated it. The Lemon test had 3 prongs. In order to be constitutional under the Establishment Clause, the law must have a secular purpose. The primary effect of the law must neither advance nor infringe on religion, and the law must not excessively entangle government with religion. The Lemon test garnered some criticism over the years for being subjective and difficult to apply. But lower courts really relied on it because, although it was imperfect, it honored the purpose of the Establishment Clause, which is to protect the religious and non-religious outsider. That is, people who don't share the religion of the people in power. Now, contrast this with what the Supreme Court replaced the Lemon test with in Kennedy, telling courts to look at history and tradition to see if the challenged action aligns with how the founders understood the Establishment Clause. The focus on history to decide constitutional cases didn't come out of nowhere. I'll talk about another area of law where it's been very prominent in a second. But in Kennedy, the court announced this as the new test of Establishment Clause cases and basically said that what the coach did was fine because his prayer at the 50-yard line would have been allowed at the founding. There are a few problems with this. First, a lot of things went on at the founding that we don't want happening now. Many religious and non-religious minorities face significant persecution. We are a much more religiously pluralistic society now than we were historically. So some things that might have been understood as secular or at least non-controversial back in the day are now clearly religious and divisive. Also, depending on what you emphasize and de-emphasize, you can use history to come to just about any conclusion you want. Judges are not professional historians, nor are most of the lawyers that are trying to persuade them, and courts have increasingly been using really sketchy historical analysis to decide cases like this. Another classic example of judges playing historian is in the Second Amendment context. The best case to illustrate this is the 2008 case of District of Columbia v. Heller, in which the Supreme Court held, in another unprecedented move, that the Second Amendment conferred an individual right to bear arms in the home for self-defense. The Second Amendment was never understood to confer an individual right to gun ownership before. It was always tied to bearing arms in a militia, as the text says. Justice Scalia wrote the opinion, which is pages and pages of history. Meanwhile, Justice Stevens wrote a lengthy dissent using extensive historical examples and analysis to come to the exact opposite conclusion. In the reproductive rights context, Justice Alito's recent decision in Dobbs overruling Roe v. Wade relied heavily on shoddy historical analysis. So remember when I said Lemon was criticized for requiring too many subjective judgments? History and tradition is at least as subjective, and it's potentially much more dangerous to a much more diverse society. In the years to come, we are only going to see more of this specious use of history to interpret the Constitution in contexts ranging from religion to guns to reproductive rights and LGBTQ plus rights. One of the newest ways the Supreme Court is using the Free Exercise Clause to try to swallow the Establishment Clause whole is through the most favored nation theory. How many of you have heard of this one, either in the religion context or outside of it? So this theory, borrowed from international law, is the idea that religion has to receive at least equal to the best legal treatment that anybody else receives. If there's any exception or more favorable treatment for anything or anybody else, and religion doesn't get it, religion is being disfavored and discriminated against. 2 years ago, the Supreme Court adopted the most favored nation theory in a shadow-docket decision. What is the shadow-docket? The shadow-docket refers to the mechanism the Supreme Court uses to quickly decide on emergency issues without full briefs and oral arguments like you would normally see. The decisions in shadow-docket cases are often unsigned, and their rationale is typically sparse, unlike with fully briefed and argued cases. So think 4 to 5 pages instead of 40 to 50 or more. In recent years, the Supreme Court has increasingly used the shadow docket to make substantive decisions on issues like the Texas abortion ban, SB 8, and it has asked lower courts to use them as precedent in future decisions, despite the fact that they aren't as well reasoned. In April 2021, the Supreme Court issued a 4-page shadow docket opinion in Tandon v. Newsom, pausing California's COVID-19 restrictions on all at-home gatherings of more than 3 households and stating, quote, "Government regulations are not neutral and generally applicable whenever they treat any comparable secular activity more favorably than religious exercise," end quote. Meaning, because retail stores, movie theaters, and indoor restaurants could bring together more than 3 households at a time, at-home religious exercise was entitled to the same under the Free Exercise Clause. And this was the case even though California's public health experts were clear that the risk of transmission was greater in at-home gatherings than in commercial settings. This was a radical shift from the court's earlier COVID-19 rulings before Justice Amy Coney Barrett, a conservative, replaced the liberal Justice Ruth Bader Ginsburg after she died. The 3 liberal justices dissented, calling out the court for comparing apples and watermelons. This decision is difficult to square with Employment Division versus Smith, which is a 1990 free exercise case holding that neutral and generally applicable laws generally don't violate the Free Exercise Clause, even if they incidentally disadvantage religious exercise. Conservatives have been attacking the Smith decision for years, asking for exactly the kind of preferential treatment for their religious beliefs that the Tandon decision and the most favored nation theory offer. So, all that to say, there is a lot to be concerned about in the courts these days. But Americans United is continuing to fight back, not only in federal courts under the federal Constitution, but also in state courts under state constitutions similar protections for church-state separation. I'll start with federal courts. Americans United's legal team both represents clients directly and files amicus briefs or friend of the court briefs in other important cases affecting church-state separation in which we don't represent a party. Last year, we filed or joined 6 amicus briefs in federal courts. So far this year, we've filed or joined 5 more. Not all of these briefs are in the U.S. Supreme Court, but I'll talk here about 2 recent Supreme Court cases you may have seen in the news. The first one is Groff v. DeJoy. This case involved Title VII, the federal law prohibiting employment discrimination based on several factors, including religion. Title VII requires employers to grant requested religious accommodations, such as time off for religious holidays, dress code modifications, etc., unless doing so would impose an undue hardship on their business. Here, a part-time postal carrier who was hired to cover holidays and weekends resigned after he claimed the Postal Service did not do enough to accommodate his request to not work on Sundays. Over 14 months, Groff refused to show up for 24 Sunday shifts, leading other employees, nearly all of whom were also church-going Christians, to resign, transfer, file grievances, or cover for him. Groff lost in the lower courts because the courts found that granting his requested accommodation, no work on Sundays, would impose an undue hardship on the Postal Service. He then asked the Supreme Court to clarify what undue hardship means and what factors employers are allowed to consider when deciding whether to grant religious accommodations. Americans United and Lambda Legal submitted an amicus brief in this case, arguing that Title VII allows employers to consider whether accommodations would impose real burdens on coworkers. Those burdens could range from logistical harms, like forcing coworkers to cover undesirable shifts, to dignitary harms, like proselytizing or misgendering coworkers. And while workplace morale is an important consideration, and granting some accommodations could negatively impact morale, we argued employers can't deny accommodations because of coworkers or customers' hostility toward the religion itself, because that would conflict with Title VII's purpose of eradicating workplace discrimination based on religion and other factors. Overall, religious freedom is meant to be a shield that protects us, not a sword used to harm others. On June 29th, the Supreme Court issued a unanimous decision in Groff, largely agreeing with our position. The court held that undue hardship means a, quote, substantial burden, end quote, in the overall context of an employer's business, and importantly, impacts on coworkers are relevant to that analysis. It also agreed that bias or hostility to a religious practice cannot justify denying an accommodation. We are relieved the Supreme Court didn't use this case to once again elevate the religious rights of some over all others. And I'll just add that the Supreme Court didn't take an ultimate position on whether the Postal Service followed the law with regard to Mr. Groff. It sent the case back to the lower court to apply this clarified standard to the facts in this case. So we don't yet know how that'll pan out. The second Supreme Court case I'll talk about is 303 Creative v. Alenus, which many of you have probably seen in the news. In this case, Lori Smith, a graphic designer who wanted to expand her business to include wedding websites, sued to challenge Colorado's public accommodation statute, which prohibits discrimination based on sexual orientation. She didn't want to be forced to create wedding websites for same-sex couples. She made both a free exercise argument and a free speech argument under the First Amendment. Because she opposes same-sex marriage on religious grounds, she claimed the law violates her free exercise rights. And because graphic design is an expressive activity, she claimed that being forced to make wedding websites with which she disagrees is compelled speech in violation of the Free Speech Clause. This may remind you of the Supreme Court's decision in the Masterpiece Cake Shop case from Colorado back in 2018. That was a challenge to the same public accommodations law by a baker who refused to bake a wedding cake for a same-sex couple. The Supreme Court in that case ruled in favor of the baker, but on very narrow grounds that were limited to the facts of that particular case, so it didn't have much effect on the law overall. 303 Creative was an effort by conservative legal groups to get a do-over of Masterpiece Cake Shop now that there is a 6-3 conservative majority on the court. The website designer lost in the 10th Circuit on both her religion and her free speech claims. The Supreme Court agreed to take the case, but it only agreed to hear the free speech claim. So while this was formally a free speech case in the Supreme Court, it's important to understand that the religion clauses and the free speech clause are deeply intertwined because a lot of activity that could be characterized as religious exercise can also be characterized as speech. Americans United filed an amicus brief in the 10th Circuit, and we joined an amicus brief in the Supreme Court, both in support of Colorado and its non-discrimination law. Unfortunately, on June 30th, the Supreme Court decided this case exactly as we expected. It ruled in favor of the graphic designer and held that to the extent a public accommodations law forces a business to express a message with which it disagrees, the law violates the free speech clause. On its face, this is a devastating decision that seriously undermines civil rights for LGBTQ plus people and other protected classes, race, sex, religion, etc. But then there's the question of how broadly this will be applied. What kinds of services count as speech? At one point, the court mentions how Lorie Smith planned to create customized and tailored websites for each couple, which makes it expressive speech. So if the website were more generic or cookie cutter, where would that leave us? One version of that question is already back at the Colorado Supreme Court in another case involving the same baker from Masterpiece Cake Shop. And what about business owners who want to put signs in their windows that say whites only or no gays allowed? That's speech. Does it count? Our amicus brief argued that in principle that would count under the approach the other side promoted and the conservative majority ultimately adopted. The majority said that kind of discrimination wouldn't be allowed under its ruling, but they make no effort to explain the distinction because, as Justice Sotomayor said in her dissent, they can't. We've also already seen conservative lawyers argue that 303 Creative has implications for employment discrimination laws. The court's opinion partially relied on free association doctrine, specifically the idea that who you associate with can express a message. So, anti-discrimination laws cannot force you to associate with someone that undermines your message. The case they relied on was about a membership association, not an employer, so it's a little different. Specifically, it was about the Boy Scouts kicking out a gay scoutmaster. But we're already seeing briefs arguing that 303 Creative means employers can discriminate if necessary to preserve their message. To illustrate the crazy times we are living in, I want to briefly talk about a 1968 case called Newman v. Piggy Park Enterprises, which Justice Sotomayor mentions in her dissent. Piggy Park concerned race discrimination in public accommodations. The owner of a drive-in barbecue chain refused to serve Black customers because it was his religious belief that integration was against the will of God. The Supreme Court addressed his free exercise argument in a single footnote in which they called that argument patently frivolous. 303 Creative, although it was decided as a free speech case, is essentially the same frivolous claim. Except 55 years later, it's no longer frivolous. The nation's highest court just endorsed it. Beyond our amicus briefs, we directly represent parties in a number of federal court cases. One of them is Garrick v. Moody Bible Institute. This case involves a First Amendment doctrine called the ministerial exception that exempts religious employers from having to comply with employment non-discrimination laws for employees that serve vital religious functions. The easiest example is a priest or a minister, hence the name ministerial exception. The rationale for the doctrine is that religious employers need to be able to hire and fire ministers at their sole discretion because government interference with that core religious decision would violate the First Amendment. When it's properly and narrowly applied, the ministerial exception helps uphold the separation of church and state by keeping government out of purely religious decisions. But religious extremists have been trying to radically expand this doctrine to make religious defendants, including schools, hospitals, nonprofits, even summer camps, effectively untouchable. Once the ministerial exception applies, employees who are considered ministers aren't protected by employment non-discrimination laws at all, meaning their religious employers can fire them for any reason, including blatant sex-based and even race-based discrimination. In Garrick, we represent the plaintiff who was fired from her teaching position at a religious school because she complained about rampant sex discrimination in the school administration. She sued the school under Title VII, claiming sex discrimination and retaliation. The school tried to get her case dismissed, arguing that she was a minister and therefore can't bring this kind of claim against the school. The lower court denied the school's motion to dismiss, and the school immediately appealed. We filed our appellate brief in September, arguing that the lower court got it right, and that the school shouldn't be allowed to appeal the lower court's decision yet, since it wasn't even a final ruling. The Federal Appeals Court has a hearing scheduled for December, where one of AU's litigation counsel will present oral argument. In addition to our federal work, this year we filed 2 new cases in state courts seeking to uphold state constitution's own establishment clauses against a new generation of attacks. Bolstered by their wins in the private school voucher cases I discussed earlier, some conservatives are now arguing that state laws preventing charter schools from teaching religious curriculum also violate the Free Exercise Clause. In June, Oklahoma approved an application for what would be the first religious charter school in the nation. The school is St. Isidore of Seville Catholic Virtual School, and it stated in its application that it intends to run the school as a Catholic school and a, quote, place of evangelization, end quote. But charter schools are public schools. Oklahoma's state laws make that abundantly clear. A religious public school would violate the Oklahoma Constitution's protections for church-state separation and free public education, as well as state laws and regulations governing charter schools. St. Isidore has also made clear that it does not plan to abide by non-discrimination laws that are, quote, inconsistent with the faith or moral teaching of the Catholic Church, end quote. In other words, it wants to be funded like a public school, but still be allowed to discriminate against students, families, and staff on the basis of gender identity, sexual orientation, and other factors. The school even claims that the ministerial exception, which only applies to private religious employers, would allow it to discriminate in employment. So on July 31st, Americans United and our partners at Education Law Center, ACLU, and Freedom from Religion Foundation filed a lawsuit challenging Oklahoma's approval of St. Isidore. The defendants, including the State Department of Education, the virtual charter school board members, and St. Isidore itself, have all filed motions to dismiss our case. Our response to those motions is due this Monday, in 2 days, so we've been hard at work. And just yesterday, the Oklahoma Attorney General filed his own lawsuit to try to stop St. Isidore from violating the state's clear laws. St. Isidore is trying to open by next fall, so this case is going to continue to unfold pretty quickly over the next few months. If you want to follow along with updates, I can share a link for you at the end to read more and sign up for our email alerts. The second case we filed in state court this year is Reverend Blackmon v. Missouri, and since I've been asked to talk about this case in particular, this case gets its own slide. This lawsuit, brought in partnership with the National Women's Law Center, argues that core constitutional protections for religious freedom are fundamentally at odds with laws that impose one religious view of abortion on everyone. Missouri has some of the strictest abortion bans in the United States. In addition to the state's total abortion ban that went into effect just hours after the U.S. Supreme Court issued the Dobbs decision overturning Roe v. Wade, the state has other bans on the books at 8, 14, 18, and 20 weeks gestation, a ban on abortion sought for certain reasons, a 72-hour mandatory waiting period, a requirement that the same physician who performs the abortion also provide information to the patient beforehand, restrictions on medication abortion, and a law allowing the Attorney General to prosecute violations of the abortion restrictions even when local prosecutors exercise their discretion not to. Missouri also has a law passed back in 1986 that says all state laws must be interpreted with the religious belief that the life of each human being begins at conception. Our lawsuit claims that these laws violate the Missouri Constitution's protections for the separation of church and state. The state constitution has 3 clauses that together prevent the state from establishing an official religion, coercing any person to participate in religious activities, compelling any person to support a system of worship, or giving preference to any form of religious faith or worship. The Missouri Supreme Court has repeatedly said that these state constitutional protections are not only more explicit, but more restrictive than the federal Establishment Clause, which I discussed earlier. But Missouri's abortion laws openly proclaim that the state legislature intends to regulate abortion to the full extent permitted in recognition that Almighty God is the author of life. One legislator, urging her colleagues to pass the state's most recent abortion bans, said, quote, "God doesn't give us a choice in this area. He is the creator of life, and I, being made in his image and likeness, don't get to choose to take that away, no matter how that child came to be. To me, life begins at conception, and my God doesn't give that option," end quote. Other legislators likewise explained that the purpose of the abortion bans was to enshrine in law the religious beliefs that life begins at conception and that abortion is wrong. The result of these laws is that Missourians are coerced and compelled to support laws that give preference to religious beliefs they may not hold, with dire consequences. We represent 14 Missouri clergy members across 7 different faith traditions as plaintiffs in this case, each of whom sees abortion access as a central part of their faith. Reverend Tracy Blackmon is our first plaintiff, which is why the case is titled Blackmon v. Missouri. She's also the one depicted on the left here. Reverend Blackmon is the Associate General Minister of Justice and Local Church Ministries for the United Church of Christ. And she has said that, quote, "My God is a God of choice. In the United Church of Christ, we believe that God intended people to have autonomy over their lives and bodies, and to have authority to make complex decisions, including whether to have an abortion," end quote. And several of our plaintiffs are Jewish. Maharat Rory Picker-Nice, the executive director of the Jewish Community Relations Council of St. Louis, explained that, quote, "Missouri's abortion bans contradict, devalue, and disrespect my religious beliefs that the life and health of a pregnant person take precedence over a fetus. Jewish law mandates the termination of a pregnancy if the life of the person carrying the fetus is in jeopardy. The claim that life begins at conception is a statement of theological belief, and that belief is explicitly not a Jewish one," end quote. And 2 of our plaintiffs are Unitarian Universalists. Reverend Molly Hausch-Gordon, a minister in Columbia, Missouri, has said that, quote, "The inherent worth and dignity of every person, the interdependence of all life, and the reliability of deeply considered personal conscience are foundational in Unitarian Universalism. My faith requires that people have the bodily autonomy to make their own deeply personal decisions about abortion and reproductive health care," end quote. Other plaintiffs include the Right Reverend Dion K. Johnson, 11th Bishop of the Episcopal Diocese of Missouri, and Reverend Barbara Pfeiffer, a retired United Methodist minister who was also a Missouri state legislator. There's more information about all 14 of our plaintiffs on our website if you care to learn more. Now, we have 2 main goals for this case. The first, of course, is to get these abortion restrictions struck down so that more people in Missouri can access abortion care. The second, though, is to push back on the public narrative that religion and religious people are uniformly opposed to abortion. Our plaintiffs have proudly supported and advocated for abortion access for decades, not in spite of, but because of their faith. I'll take a brief detour here to distinguish our case from some of the other recent religious freedom challenges to abortion restrictions across the country. Our case challenges Missouri's laws under the state constitution's establishment clauses. Several Jewish groups in states like Florida and Indiana are challenging their state's abortion bans under state laws called Religious Freedom Restoration Acts because they don't leave exceptions for people whose sincere religious beliefs require abortion access in certain circumstances. If they win on those claims, they'll receive an exemption from the abortion bans only for people who share those sincere religious beliefs. If we win our lawsuit, the abortion restrictions we challenge will be struck down entirely. We filed our original complaint, which is the legal document that starts a lawsuit, on January 19th of this year, just a few days shy of the 50th anniversary of Roe v. Wade. The state of Missouri filed a motion to dismiss our lawsuit this past May. They made several arguments as to why our case should be thrown out. First, they argued that the statement, "life begins at conception," isn't religious, it's scientific. But we know that's not true. The term conception is not a medical or scientific term, and the exact moment when life begins cannot be determined as a matter of science. Rather, when life begins and whether or when ensoulment occurs are theological and philosophical questions about which different religions and individuals have different perspectives. For example, the Catholic Church has adopted the view that human life begins at conception. Other religions, like Judaism, see life as beginning at first breath. And others still, like Islam, do not believe that a fetus has a soul until 120 days into pregnancy. By legislating that life begins at conception, the Missouri legislature dictated one narrow Christian perspective onto all of Missouri's diverse faith communities. The state also argued that our case should be dismissed because, if the court ultimately rules in our favor, the court would just be establishing in law the plaintiff's religious beliefs that abortion care should be accessible. But there's a big difference between a law or a ruling that happens to coincide with religious beliefs, like laws against murder and theft, and laws that were expressly intended to impose religion. The Missouri legislature made clear that its abortion restrictions fall into that latter category, which is why they're unconstitutional and why a ruling striking them down wouldn't be. Finally, the state argued that our case should be dismissed because if we win, it would discriminate against religious lawmakers by treating them worse than non-religious lawmakers who pass laws in line with their beliefs. But the state relied on the federal Constitution's free exercise clause, which you may remember protects private individuals against government infringement of religious exercise. That clause has never given state actors like Missouri lawmakers permission to impose their religion in the law. The court held a hearing on the state's motion to dismiss in June, and I went to St. Louis to explain why their arguments are extreme distortions of both the state and federal constitutions. Fortunately, the court largely agreed with us. On June 30th, the judge held that our challenges to some of Missouri's older abortion bans aren't ripe for the court's review while the total abortion ban supersedes them, but he allowed our case to go forward challenging the total ban, the medication abortion restrictions, and the Attorney General's concurrent jurisdiction law. The judge also addressed some procedural questions about our plaintiff's legal standing to bring the case and dismissed some prosecutors from the lawsuit. Though we largely prevailed on the motion to dismiss, the state is once again trying to get our case thrown out. Last month, they filed a motion for judgment on the pleadings, essentially rehashing some of their arguments from the motion to dismiss and once again mischaracterizing our claims. Our response to that motion is due this upcoming Friday, so I have been hard at work again with our team drafting that, and next month I'll go back to St. Louis for a hearing on the state's motion to argue that our case should once again be allowed to proceed. After the trial court makes a final decision in the case, that decision can be appealed, and in Missouri State Court, appeals on constitutional decisions go straight to the Missouri Supreme Court. Now, we don't expect that the U.S. Supreme Court will ever have a say in this case. All of our claims are under Missouri's state constitution, so the Missouri Supreme Court is the final arbiter of what those words mean. But the U.S. Supreme Court can review the case if the final decision involves a federal issue, like a conflict between the state constitution and the federal constitution. And as this presentation has probably made clear, the current U.S. Supreme Court has shown itself to be very aggressive on religious liberty issues in recent years. I'll mention again, if you're interested in keeping up with this case as it develops, I encourage you to check out our website and sign up for our email updates. I know this wasn't the cheeriest presentation in the world, but I hope I've helped you understand how we got where we are and where we might be going next in the fight for church-state separation and our basic civil rights. I'm happy to answer any questions you may have, and if for some reason I'm not able to get to your question today, I would be happy to answer it over email. My email is jocelyn@au.org. Thank you so much again to the Humanist Society for having me, and thank you all for attending.
Thank you, Kalli. Very much appreciate you pulling that presentation together for us. But yes, it is a little demoralizing. Glad you're in there fighting the good fight. When you went in June posing the motion to dismiss, were you nervous? Like, I mean, on a personal level, what was it like for you being in that courtroom in Missouri and making the case? Or were you like ramped up? How did it occur for you?
Yeah, I was a little nervous. It was also my first oral argument, so that was a kind of a big milestone for me, but I felt really well supported by co-counsel, and I also wasn't tackling it alone. I split the oral argument with one of the attorneys at the National Women's Law Center who we're bringing the case with, and she did an excellent job as well, so it was really nice to have that support.
Great, fantastic. Okay, do we have any questions? We have some comments in the chat. Oh, Larry Taylor says that he met the original Alton Lemon, at a Philadelphia humanist meeting. How long ago was that, Larry?
It was at least 25 years.
Wow. And I see you also believe every word that Jesus said about abortion. You wrote that in the chat.
Oh, yeah. Would you like a list?
Yep. See, do we have any other questions or comments for Kalli? Wayne.
I guess one thing is, being that the Supreme Court has seen so much of a lost cause, should we really be pursuing this? Just have to pursue it legislatively? Is that kind of the only chance? Could be advanced legislatively, and then they would have to fight them in the Supreme Court again, but it might give us a breather of reality or reasonable laws.
Yeah, so between legislation and litigation, I definitely don't think it's an either or thing. I think we should definitely be doing both. And with litigation, you can be doing both offensive and defensive work. We're hoping to make gains in this area where we can, but we're also hoping to stop the backsliding of our civil rights as much as possible. So sometimes we are in that defensive posture, but just because the Supreme Court has not been in our favor in recent years absolutely does not mean we should give up the fight.
Thanks.
With all of these decisions that have, say, undermined Lemon and overturned Roe v. Wade, how does that get changed? Like, is that like a future court? Is it easy for them to go back and say, oh no, that they decided that on grounds that don't make sense? I mean, how does that go, the back and forth over time with Supreme Court decisions? How stuck are we with a decision?
Yeah, that's a good question. So both Roe v. Wade and Lemon were interpreting constitutional provisions. So unfortunately, the only way to change that is either with another Supreme Court opinion, probably with a different makeup on the court, or with a constitutional amendment. And both of those are not terribly easy to get. But there's other Supreme Court decisions interpreting statutes that Congress has passed, for example. And if the Supreme Court gets it wrong there, Congress can just pass a new law saying the court didn't interpret it correctly. Here's what we actually mean.
Thank you.
Yeah.
Andrew, yes.
Hi, Kalli. Thank you so much for all you're doing for the citizens of America. I really appreciate very important work. I heard you mention Freedom from Religion Foundation. I'm just curious, how many groups do you coordinate with? Is it a common for you guys to get together and team up against this stuff? Just tell me kind of what kind of cooperation you have with other groups. How do these groups determine which cases they're going to take, and is there any coordination between you guys?
Yeah, definitely. So it's a lot of conversations. A lot of the people, especially working in this space, in the church-state separation space, have been doing this for years and are very well acquainted with the other organizations doing this work. So we're definitely in a lot of the same spaces as Freedom from Religion Foundation. And we're constantly talking with coalition partners as we're developing cases or as we're deciding whether to file an amicus brief or what arguments to make in an amicus brief, for example. So even if we're not bringing a case together, we may still be in conversation with other groups about how our litigation could impact other litigation, or different approaches we might want to take. With our amicus briefs especially, we frequently have coalition partners either joining our amicus briefs, or if we are not writing the amicus brief ourselves, we are joining one of our coalition partners' amicus briefs. We are all in this fight together.
Awesome. Thank you.
Absolutely.
One of the things that distinguishes Americans United is that you routinely are cooperating with religious organizations who also care about the separation of religion from government, to be able to protect their religion from other religious majorities stomping on them.
Yes, absolutely.
Thank you so much for taking the time on a Saturday evening to join us here.
Thank you so much again for having me. This is really wonderful.
That's it. So thank you all for attending. Thank you again, Kalli Joslin, for gracing us with your presence, and especially for all the work that you're doing fighting for our rights.